A criminal case refers to a legal proceeding in which the state or government brings charges against an individual or entity for committing a crime. The purpose of a criminal case is to determine the guilt or innocence of the accused and, if found guilty, to impose appropriate punishment. Here are the typical stages of a criminal case. Investigation. Law enforcement agencies gather evidence, interview witnesses, and collect information to determine if a crime has been committed and identify potential suspects. Arrest. If there is sufficient evidence, the police may arrest the suspect. The arrest can occur either with or without a warrant, depending on the circumstances and the seriousness of the alleged crime. Booking. The suspect is taken to a police station or a correctional facility, where they undergo a series of administrative procedures. This includes recording personal information, taking fingerprints and photographs, and storing personal belongings. Initial appearance. The suspect appears before a judge or magistrate. During this stage, the charges against them are read, and they are informed of their rights, such as the right to an attorney and the right to remain silent. Bail may also be set at this stage. Preliminary hearing. Grand jury. In some jurisdictions, a preliminary hearing is held to determine if there is enough evidence to proceed to trial. The prosecution presents evidence and witnesses, and the defense has an opportunity to challenge the evidence. Alternatively, a grand jury may be convened to review the evidence and decide whether there is enough probable cause to indict the defendant and proceed to trial. Arraignment. The defendant appears in court, where they enter a formal plea of guilty, not guilty, or no contest. The judge may set or modify bail conditions, and the trial date is typically scheduled. Discovery. Both the prosecution and defense exchange evidence and information relevant to the case. This includes witness statements, expert reports, and any other evidence that may be presented at trial. Pre-trial motions. Attorneys for both sides may file motions with the court. These motions can address issues such as suppressing evidence, dismissing the case, or requesting a change of venue. The judge reviews and rules on these motions. Plea bargaining. The prosecution and defense may negotiate a plea bargain, in which the defendant agrees to plead guilty to a lesser charge or accept a lighter sentence in exchange for avoiding a trial. Trial. If the case proceeds to trial, both sides present their evidence, call witnesses, and make arguments before a judge or jury. The prosecution must prove the guilt of the accused beyond a reasonable doubt. Verdict. After considering the evidence and arguments, the judge or jury deliberates and reaches a verdict of guilty or not guilty. In some jurisdictions, the jury's verdict must be unanimous. Sentencing. If the defendant is found guilty, the court imposes a sentence. This may include fines, probation, community service, or imprisonment, depending on the nature of the crime and relevant laws. Appeals. The convicted person or their defense attorney can file an appeal to a higher court, seeking a review of the trial court's decision. Appellate courts examine issues such as legal errors or constitutional violations that may have affected the outcome of the case. It's important to note that the stages and procedures can vary to some extent depending on the jurisdiction and legal system in place.